Maintenance and conduct. This is an obligation on the part of the tenant. This shows, as we go down the blips, the tenant shall comply with building codes and housing codes. The tenant shall keep, these are mandatory words, keep the premises clean and safe. The tenant shall dispose of rubbish, garbage, and other waste through the proper collection receptacles or designation collection areas. And the tenant shall not deliberately or negligently destroy or deface, damage, or remove any part of the premises. And the tenant shall act and require other persons to act on the property in a manner that will not disturb the neighborhood's peaceful enjoyment of the premises. So keep that in mind if you have neighbors who are complaining because you have people who are living in your property and they're causing a disturbance through noise or through other activities that are on the property, and your complaints are coming in, police are starting to come in and file reports. You're going to need to get copies of those incident reports and police investigation, what happened, loud noise, complaints, so forth, because if you're going to rely on that, and that would be good, when we get to 66-28-505, where you have to send a 14-day notice for them to correct their behavior, you have to have some backup for that, and you have to tell them the reasons. So it's important that you have that, but those are conditions of the tenant. Again, something you might specifically put in your lease, making reference to the statute. You can set these out specifically. You can put it in your rules and regulations that you attach and incorporate by reference. These are conditions that you're putting on the tenant to live in your property and to how they will conduct and themselves in your property. Rules and regulations. Like I said, a landlord from time to time, they can make it a part of their lease and they can modify these. They can't, and they can make it effective if you go 6 months and some changes have come up and you've noticed some other things that are going on, you can make a change to your rules and regulations and you give written notice to the tenant. And you need to provide in your lease that these rules and modifications are modifiable and they can be given notice. Now, the only reason that are not effective, these modifications, would be if the rules and regulations don't apply to all tenants. Well, if you're leasing a house, that's not going to be an issue. But if you have apartment complexes, that could be a problem. Because if you're trying to zero in on one person, you can't just make that rule apply to that one person. It has to apply to everybody in the complex. But typically, if you've got just a house and you're renting it, then that rule and regulation is going to apply to them, and it's not an inconvenience. It's something they have to start living with. And those rules and regulations, once amended, are effective against the tenant once you give them written notice of that and the adoption of that. Abandonment. And excuse me, all these references at the top, 66-28-405, that's the Tennessee Code annotated. That's under the Landlord Residential Tenant Act, okay, Uniform Residential Landlord Tenant Act. So I just didn't put the TCA, but that's Tennessee Code annotated 66-28-405. You can go online and get a copy of the Act. You can find that and find all these sections that I'm putting out here to you. As it says here, the tenant's unexplained absence, extended absence from the premises for 30 days or more without rent, without the rent payment, the landlord then is expressly authorized to enter the property and take possession of the premises. Now, the next section may sound like, wait a minute, what are you doing here? It says non-payment of rent for 15 days past the rental due date plus reasonable factual basis for thinking that the tenant has in fact abandoned the property, to wit, termination of utilities. The place, you look through the windows and you see that the place is vacant. There's no furniture in there. It's all gone. there may be some trash on the floor or whatever, that's an indication that they're gone. The door's unlocked and anybody can go in and out of it. And those, you need to document that information. You need to take pictures for your own protection, particularly if you enter into that property. Because if you step into that property, and you have a reasonable right to do that as a landlord to preserve your property, but keep in mind that tenant may say, well, I had a lot of property there and now it's gone, and you came into my property and you don't have any proof. He said, oh yeah, and he has 2 or 3 witnesses who are helping him or her get to make a claim that they've left some valuable property in that residence. If you've gone in and you've taken pictures and you keep those pictures, you print them out on your computer or you have wherever, but you have a log and you can show the court, this is the condition of the property as I opened the front door and here's what it looked like as I went through each room. Then you've got proof. They're going to have a hard way, but you're protecting yourself. Take a witness with you also, so you've got backup to the pictures, okay? But if the on the 15-day notice proposition, you must post notice, okay? You have to post notice on the door. You have to give a 10-day notification to the tenant that if they don't respond to you in 10 days, you're going to enter the property. That's on the 15-day notification. The 30-day notification is it's 30 days, no rent, and you haven't heard from them. You've got a right to go in and take possession of the property and remove their possessions. But under the 15-day notice, to expedite that process, you have to go in, the landlord re-enters, and unless the tenants contacts you within 10 days, then you can take possession and remove all their personal belongings from the property. Typically, if they're gone, rent's not paid, if they're abandoned, they're not going to contact you in 10 days. You know that, but this is a process, again, to protect yourself as a landlord from being sued for having removed property without having complied with the statute. I realize that most of this stuff on the 15 days is probably a 15-day notification. All their furniture may be gone. It does require under this act that you must take all their personal property and store it for 30 days. That's an expense you're going to incur. You can't just dispose of it. You have to hold it for 30 days. After 30 days, you then can sell it. Well, that's another reason, and you can reimburse yourself for the, where is this? For the damages that you've incurred, the rents that they owe you, any cost, fees, and attorney fees that may come into play. But let's be realistic about this. If somebody's packed up and moved out of your home and they've taken all their furniture, what's left isn't going to be anything that's going to be worth stored. But you have to use discretion. You have to have good judgment on what you're doing. Take pictures of what they've left so you've got a record of it. So if you don't want to fool with storing that stuff and you're going to trash it, you better have records as to what it looked like and what kind of condition it was in. If you've got that, they're going to have a hard way. Pictures don't lie and they tell a very good story. So I would urge you to do that. Should they leave any property in there and you do sell that property, you have to hold the proceeds for 6 months. Why 6 months is beyond me, but I would assume by the time you get to the 30 days or you get to here, you're going to have a couple of months rent, you're going to have the storage fees that you have, and I doubt that you're going to get much money unless it's a whole house full of furniture and you have a great yard sale in the process that earns a lot of money. You're not going to get much, so you probably won't have any excess, but in the event that you do, the statute requires you to hold it for 6 months. It doesn't say what to do with it after 6 months, but if they don't come back and claim it, I would move it into my own account. It would be considered as a waiver and a bond, all right? But the statute doesn't specify that. Tenant non-compliance. Here we go. This refers us back, the 6628-505. This statute refers us back to what the tenant is supposed to do under 6628-401, where we said the tenant shall comply with building codes. The tenant shall keep the property clean and safe. The tenant, all those things are going on. The non-compliance here is where now we're getting into the notice, and that's one of the forms that you've got. I've got it styled as a 14-day notice if you've got it out in one of the forms. If you don't have a waiver of this provision in your lease, you have to send out this notice of non-compliance and specify in that notice what the problems are, and they've got 14 days to remedy the situation. If at the end of 14 days you make an inspection and they have not remedied the problem, or it's continuing or whatever, then in your notice you're telling them that the lease will terminate and you can commence eviction. All right? Now, this statute's been amended, and it used to be you had to go 14 days and tell them they had up to the lease would terminate after 14 days, at the end of 30 days. They've removed that, so it's now been reduced, which is good, 14 days, but it's a lot better because under this statute, you can provide for a waiver. That has to be in the lease. It has to be there, and it has to be of a certain bold print, 12-point bold print, that they're waiving both rent and notice of material non-compliance. You have that in your lease. You don't have to send the 14-day notice. You can start your eviction if they, if you can go over there to tell them to clean it up and they don't, you can go start your eviction. That's your decision. But certainly if they're not paying you rent.